The nation's highest court, in a 9-0 decision, reversed the Colorado Supreme Court decision that declared Trump ineligible based on the insurrection clause of the 14th Amendment. 9 News political reporter Marshall Zellinger is here. You've been following this from the get-go, Marshall. The case ended up being Trump versus Anderson. The namesake, Norma Anderson, is not surprised by the decision.
Norma Anderson, the former Republican state lawmaker, knew after the Supreme Court hearing earlier this month in Washington, D.C., that she would not win her challenge to keep Trump off the primary ballot, though her legal team saw several silver linings in the 9-0 decision against them. The attorneys for Anderson and the 5 other Colorado voters who challenged Trump's eligibility told me today that winning was only part of their goal. They said they wanted people to know the 14th Amendment exists and has power and force. Section 3 of the 14th Amendment says that someone who has previously taken the oath to defend the Constitution cannot hold office if they are an insurrectionist. Today, the U.S. Supreme Court ruled that individual states cannot determine that for federal offices. In the 9-0 decision, the court wrote, "We conclude that states may disqualify persons holding or attempting to hold state office, but states have no power under the Constitution to enforce Section 3 with respect to federal offices, especially the presidency." When I talked with the attorneys, I asked how they see silver linings in a ruling that feels like Super Bowl 24 when the Denver Broncos were blown out by the 49ers 55-10.
We did lose, but unlike the Broncos analogy, what happened here was that Donald Trump asked the court to do several things, any one of which would have resulted in a victory for him. They only did the narrowest, most procedural one. So I would analyze this more, not as a 55-10 defeat, but as a game that was decided by the refs.
According to Anderson's lawyers, they got the attention on the 14th Amendment that can be used for decades. However, the decision also said that Congress needs to pass legislation for Section 3 of the 14th Amendment to be used, meaning minus a bill from Congress saying they dictate the insurrection clause or a court can dictate the insurrection clause, it kind of can't be used right now.
You're talking about the blowout, the 9-0 decision today, and there's a reason there aren't many 9-0 decisions. Cases that are clearly one way or the other don't often make it to the court, or the court won't even take them.
Sure, and you're going to hear from a constitutional law attorney in a little bit, Jessica Smith. I talked with her earlier today for a story that I'm going to air on next about the idea, did the Colorado State Supreme Court really screw this up somehow? And she told me, no, they were protecting Colorado law and the Colorado election law that says you can challenge someone's eligibility in court and that it's the Secretary of State that can deem someone ineligible based on factors that were decided in Colorado, but that the Supreme Court has a different purview of making sure it works federally.
Well, if nothing else, you brought back that special Sunday in New Orleans, that 55-10 game. Thanks for that, Marshall.
And Norma, though, I think is really proud of her efforts and what she's done.
She still says today that she defended democracy and would continue to do so. She said in the few years she has left, that part left me a little uncomfortable, but at 91, she's got a long life still to go, has no regrets about doing this. Again, not surprised by the decision, but a little concerned, she said, about the extended part of the decision that made it beyond the states don't have control of this.
Certainly much more about this to come over the next day or so. We'll be turning to you for more on that, and we will be talking with Jessica Smith in a couple minutes.